again, I watch way too much YouTube. There's a lot of interesting videos about the founding fathers wanted no longer to have debtor's prison.
Well, I get that.
They wanted
And
to
I
have
agree.
bankruptcy. People make a fresh start.
After that will be 544, Real Water's motion in limine to exclude financial records or information of non-parties, motion in limine number 15.
And this, Mr. Kaufmann will be presenting on.
Oh, I'm doing this one? Okay. Hang on. Hang on. So, Your Honor, just give me 2 seconds to reorient my stuff. I was
Take
on
your
the
time,
motion
yeah.
after this.
Yeah, take your time.
So this motion is aimed at punitive damage phase and plaintiff's expert Mark Rich. And Mr. Rich, I'm sure you're aware after reading the reports and everything, has included financial information for a number of non-parties to this case in his report. For example, he reviewed some of the financial information for Coke, Pepsi, Nestle, Thermo Fisher, and Granger. To begin with, Thermo Fisher and Granger, Thermo Fisher is an instrument manufacturing company, and I don't think is relevant anymore because the ORP meter defendants are no longer in this case, are not in this trial. Likewise, Granger is a distributor, and I'm not sure Granger's net worth or financials are relevant to this trial, given that there's no distributor or retailer in the case as well. So that leaves Coke, Pepsi, and Nestle. And as I'm sure you're aware, during the Gallagher trial and other trials, plaintiffs have pointed to the market power and market value of Coke, Pepsi, and Nestle in order to argue deterrence. Now, I want to make really clear, just so we can save some time today, I'm not disputing Mr. Rich's qualifications. Mr. Rich is a CPA. He's qualified to make these opinions. So I just want to short circuit that to begin with. My issue is that I don't think evidence of non-parties is probative to anything here. You know, we've tried 3 of these cases at this point, Your Honor. And in each case, Real Water is the last defendant standing when this case goes to the jury. And Mr. Rich has never testified in any of these cases. And, you know, I don't see why his testimony would suddenly be relevant after being unnecessary in the last 3 trials as part of it. I also think that Mr. Rich's by imputing companies and throwing out companies like Coke and everything that you know, it's making Real Water seem bigger than it really was. And I don't think that's very fair to Real Water because I think it creates a false sense of size in the jury and will lead to an improper verdict. And with that, you know, I'll reserve some time for rebuttal.
Thank you, sir.
Your Honor, I'm handling this one. And let me start off with the low-hanging fruit that my friend, Mr. Kaufmann just gave me. I appreciate it too, Matt. Your Honor, Mr. Rich did testify during the last trial. And I thought that Mr. Kaufmann was there, but he may have left early because he was flying back. I'm not sure. Maybe he just forgot.
Teddy, I did leave, and if you did testify, I apologize. I did not mean to misrepresent that to.
No, I don't think you meant to misrepresent it, Matt. I have no belief in my mind that you would intentionally steer the court in the wrong direction. Your Honor, this issue started in terms of Mr. Rich's ability to testify in this court. And you gave us the right to use Mr. Rich in trial because at that point we were concerned about the meter defendants. And in fact, the court may remember this. Following a day of court, you allowed us to go and do the deposition of the meter person, and they were allowed to do the deposition they wanted to of Mr. Rich for purposes of punitive damage phase of the trial. The following day, the jury did not strike the box for the meter defendants, and so Mr. Rich was not necessary. But we'd already teed that issue up, and we discussed that, in fact, in front of Judge Hardy. I have a copy of the motion that went before Judge Hardy in the Wren case. And, Your Honor, we went through this prior to Mr. Rich taking the stand in the Wren trial. And he did testify. And he testified to exactly what Mr. Kaufmann is trying to prevent at this point. We filed, I don't know if the court saw it, we filed a supplement on Monday. And, Your Honor, we brought copies of it with us, but we filed a supplement and we didn't add any argument. We simply attached the transcript from June 17, 2024, when Mr. Odou and myself discussed this very issue with Judge Hardy. And certainly, I'm assuming Mr. Odou recalls the argument. And I brought a copy, if you don't have a copy of the supplement, Joel.
We object to it. It's not proper. This court's gonna make its own decisions. Judge Hardy made his decisions, and obviously, we object to that verdict because it's unconstitutional. So that's opening a can of worms by even going down that road.
Okay, but that's your humble opinion.
No, actually, you guys agreed with me that a verdict over a certain amount would be unconstitutional.
State Farm,
I'm not agreeing with that.
State Farm case, is that what you're relying?
Yeah, the plaintiffs agreed in argument. If it was over a certain amount, it would be unconstitutional. I'm just
Listen,
saying
all I'm-
what's in that case.
No,
You
what
keep
I'm-
bringing it up.
What I'm saying is, we filed a supplement yesterday. In the event there were some faulty recollections of what happened in front of Judge Hardy.
Well, I can tell you, and I don't mind saying this, and this is kind of how I look at it. I don't think I've ever relied upon another judge's decision in close to 19 years.
We understand that.
Yeah, I'm an independent thinker. I'm looking at it from this perspective. Is there some sort of fact? No, I'll rephrase that. I want to make sure I understand what the argument will be. How about that?
Certainly.
That's kind of the best way. And because I'm looking at through this lens, on page 5 of the opposition, and this was raised, it says, Mr. Mark Rich relied on various evidence that is relevant to the determination of exemplary damages. As Mr. Rich reviews hundreds of pages of publicly available SEC forms, 10Q forms, and market cap information for Coca-Cola, Pepsi-Cola, and the 2023 interim financial statements for Nestle. And so my point is, how is all that wrong?
Okay, and so, Your Honor, let's
You see where I'm
start.
going on that?
I
That's
do,
Yeah.
I do. And we
I
had
think,
this,
isn't that really the thrust of the motion?
That's the
Absolutely.
thrust of the motion and the thrust of our opposition.
and so, Your Honor, in terms of relevance, let's talk about what NRS 42.005 says.
Slow down.
All right,
I always like to follow statute.
that makes two of us, Your Honor.
42005.
Yes, sir.
I assume we're going to deterrence.
Absolutely.
How do I know that?
That's exactly where we're going.
How did I know that?
That's a nasty word in the world of real water, Your Honor. They seem to hate that word, and I think they hate the fact that NRS 42.005 says that punitive damages are that's one of the purposes. And this is on page 4 of our opposition. If you could put that up for me, Jay. The paragraph starting at line 11 through 21.
Okay, I'm at the statute right now for the record.
And Your Honor, you can read within the statute and that it indicates that it's for the purposes not only of punishing by way of the defendant, but for an example and to deter and warn others that such conduct will not be tolerated. That's what we have in our brief citing to the Bon Jovi case. But we also reference, of course, the Dean Witter case as well, and the Ramada Inns versus Sharp case, Your Honor. So when Mr. Rich was allowed to testify in the Wren case, as we were suggesting he should be allowed in this case, we were faced with the prospect of Real Water saying that we're in bankruptcy and there's no amount of money that can be awarded that we would have to pay. Or we're a small company and as a result, there's no reason to award punitive damages. Something that they argued during the Gallagher trial, not the bankruptcy part, but they gratuitously threw out remarks about how small the company was. This is a family-owned company. Don't hit us with the punitive damages. We didn't know all the things that they were trying to do to avoid the consequences of their misconduct. But Your Honor, NRS 42.005 is not only for purposes of punishing Real Water for its misconduct, but also prevent other people, other situated companies in that industry from committing the same misconduct. And that was the argument that we put forth in front of Judge Hardy. And in fact, in front of Judge Hardy, we raised the point of Your Honor allowing us to use Mr. Rich in that trial if it was necessary. We told, of course, Judge Hardy that it was not necessary at the end of the day, but we informed Judge Hardy of the oral arguments we had before Your Honor. And in fact, in front of Judge Kishner, he was also going to be allowed to testify, but Terrell Wilker settled during trial and it became unnecessary. So, Your Honor, we focused the third trial on deterrence. And we put in front of Judge Hardy all of the information that Mr. Rich had and he was relying upon to determine what this industry's value is and what type of monetary message you would have to send to actually have an impact on this industry to prevent this type of misconduct. What I thought was somewhat novel and creative was the suggestion in front of Judge Hardy, which I suspect will come today, that for some reason, the deterrence meant to only deter Real Water from committing similar conduct. But I don't think that the statute can be read in an intellectually honest manner by saying that, because it says by which others may be deterred and warned. This is what the Supreme Court has taken from NRS 42.005. So, Your Honor, we believe that when you look at the marketplace, you have to consider those who are in the bottled water space. And that would be the companies that we identified in our opposition, page 4, lines 22 through 28. They occupy that space. And as a result, we should be able to provide that testimony to the jury so they understand what it takes to deter this type of misconduct. One thing I appreciate that Mr. Kaufmann said was that Mr. Rich certainly has the required credentials. He's using information that is reliable, that if it was to be tested from another CPA, that it's tested and testable. It certainly will assist the trier of fact. So I believe it meets all of the hallmark requirements, which we lay out on page 5 of our opposition, Your Honor. And then certainly I don't believe there's been an argument as to credibility of Mr. Rich's testimony. Your Honor, just to hit on what Mr. Odou said earlier, in front of the prior trial, we asked for 1.7 million. I'm sorry, 1.7 billion.
Pretty slow.
And the jury gave us 3. But conversely, Mr. Odou suggested to that jury somewhere around $500 million. And so certainly, and I want the court to consider this, and I thought it was important today, certainly, he could not suggest $500 million as an appropriate punitive damage amount if he was not also considering the benefit of deterring others in that space. Because we know a bankrupt company couldn't pay $500 million. We know that the mother and pop shop that he was describing this company as couldn't pay 500 million. So he was suggesting that somewhere around $500 million was the appropriate number to deter others in that space. The jury just happened to agree more with us than with him. And Your Honor, there is no reason, given that they're not contesting Mr. Rich's ability to testify from a Hallmark perspective or from a NRS 50.267 perspective, that he should, I'm sorry, 265 perspective, that Mr. Rich should not be allowed to testify. Does Your Honor have any questions or concerns about this?
No, I'm listening, and I'm just thinking about the statutory scheme.
All right.
The reason why that's important, because remember, at the end of the day, and countrywide, that's what Justice Perriger talked about. Because he said, he said, we have all these cases out here specifically involving punitive damages, and they're all over the place. He said, what you need to do is look at the statute. That's what I take from countrywide.
Right, and that's what the supplement that we provided, Your Honor, there was a tremendous amount of time that we spent going over this with Judge Hardy. And again, I know that you will make your own decision, but that's where we started when we first brought it to your attention. And I will tell you, when we brought it to your attention, us bringing it to your attention was mentioned in front of Judge Hardy as well. And he made his own decisions, but I wanted him to be aware of what this court did and what Judge Kishner did. And neither of those judges, nor did you in the first trial, preclude Mr. Rich from testifying. So we're asking the court to remain steadfast in its position. We believe that the statute provides the relevance, which is to deter others from committing such misconduct in the future. And certainly, he's been deposed, he's been
And
cross-examined.
where's that specific language? I just want to make sure I'm clear.
NRS 42.005.
Yes.
Can you put that up on the screen, please? It is paraphrased from the case law in the opposition. 42.00.
Because I do understand how important insurance is.
Absolutely, yeah. And it says right here, Your Honor, paragraph 1. Except as otherwise provided in NRS 42.007, in an action for the breach of obligation not arising from contract, where it is proved by clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice, expressed or implied, the plaintiff, in addition to the compensatory damages, may recover damages for the sake of example and by way of punishing the defendant. So the question is, for the sake of example, who is the example for? And then you go to the Supreme Court's decision in Bon Jovi, which I tried that case, Your Honor, says by which others may be deterred and warned that such conduct will not be tolerated. It's also, I believe, in the Nevada pattern jury instructions on punitive damages. And that is, I think it's 7.
15.
Is it 7? Is it 15?
15 something.
I'm
I've been arguing about it.
because Your Honor, I know it's in the pattern jury instructions. I can't remember which provision it is, but it's also there as well. But the Supreme Court has interpreted this to mean to deter others from committing such misconduct. And again, that was, like I said, I tried that Bon Jovi case, and Mr. Posenberg, we retained him in that case to represent Dr. Bon Jovi. That was in front of the Supreme Court Justice Perriger, as a matter of fact. And if we could, I'm trying to find, if we could find a pattern jury instruction on it, you know, I'd like to show that as well.
Yeah, I think
Here
countrywide.
it is, right here.
Yeah, I think countrywide was his best decision. I really do.
It was a good one.
It's good. Clarified a lot.
Yeah, and it says again, damages are to make an example of or punish wrongful conduct. You know? So I think it's pretty clear by the Nevada Supreme Court's decision that Mr. Rich's testimony would be relevant. It is gonna allow a jury to understand what type of numbers are appropriate to deter this type of misconduct in this bottled water space. And that's what we use it for. And in fact, Your Honor, when he testified during the last trial, he confined his testimony to bottled water space. He didn't get into alcoholic beverages, for example, wine, beer, spirits, none of that stuff. He didn't do it on food. He did it strictly on the bottled water space. Any other concerns, Sean?
No. I'm just thinking.
All right. Thank you, Your Honor.
I'm just
Your Honor, I
thinking.
hate to steal Mr. Kaufman's thunder, but there's some things that obviously I need to address because they were addressed to me. As an initial matter, in the Wren case, there was a verdict of approximately $90 million. We suggested to the jury a constitutional punitive damages awards of several times that verdict if the jury were to award punitive damages, and this was in the punitive damages state. So for plaintiffs to now say, oh, well, that means we concede that that amount is reasonable is absurd. And to say that that amount would deter is also absurd. That amount would have been excessive. That amount was just going to be constitutional, not necessarily still excessive, because it is still excessive. So plaintiffs are mistaken in that regard. The second thing plaintiffs are mistaken about, and I'm going to use an absurd example, just to take this to its extreme, like the plaintiffs would like to do. The plaintiffs would like to use Coca-Cola as an example for this court to say, well, this court should award, or this court should allow Mark Rich to testify as to the net value of Coca-Cola because they're in the same business of real water. They're not in the same business. Coca-Cola is diversified. They own, who knows how many things they own. I could ask Mr. Rich that, but that just amplifies the prejudice to the jury. It's like arguing that somebody who is delivering Coca-Cola to somebody's house and gets in a car accident because they were drunk while delivering. Well, you've got to send a message to Coca-Cola and send a message to this delivery driver and award $3 billion in punitive damages against this delivery driver. So Coca-Cola will make sure that delivery drivers are not drunk. I mean, that is just absurd. And to hold out real water and say real water is the same size as Nestle or in the same industry as Nestle or is in the same industry as Coca-Cola or in the same industry as Pepsi, that's a farce, Your Honor. They're not even in the same neighborhood. They're not even on the same planet. Real water in its best years had $9 million in sales. That was sales. That wasn't even profit. Real water was not profitable. Real water probably would have gone bankrupt without this case. Went bankrupt anyways. And to say that, oh, well, we're going to allow the jury to hear evidence of the size of these gigantic mega corporations and use that as some type of yardstick as evidence in this case is prejudicial. It led to the unconstitutional jury verdict in the Wren case, and we shouldn't repeat that mistake here. We objected to Mr. Rich because he wasn't designated as an expert to testify against real water in any case. He was testifying against UNFW, UNFI, whichever one you want to call it, and the meter defendants. And now the plaintiffs have adopted those opinions and tried to bootstrap those opinions against real water. And Your Honor, punishing real water is one thing, but to punish real water using the scale of Pepsi, Coca-Cola, or Nestle, that's just absurd. And that's unconstitutional. It's improper. It's as prejudicial as possible. There really isn't any other more prejudicial thing to do than say, oh, well, this company that had $9 million in sales for a couple of years in its best years before these plaintiffs were injured should be punished at the same scale, and we should send a message. This send a message argument really has been abused in these cases and has really led to some really outrageous jury verdicts that are many times what the Constitution allows. And to allow Mr. Rich to testify invites that type of error. Yes, there are post-trial motions coming in Wren. Yes, the court can reduce the award if it's unconstitutional. I'm sure the court will. In fact, the plaintiffs even conceded in Wren that an award of that size would be unconstitutional before it was given. But why are we inviting this type of award? There's no reason. And again, the plaintiffs want to say, oh, well, we want to punish some insurance carrier who's not a party to this case. Well, that doesn't make sense. That's not allowed. The insurance carrier is not a party to this case. Oh, well, we want
And I
to.
just have one question for you, Mr. Odou. As far as the constitutionality, you're relying upon a State Farm case? Is that
Yes,
it?
Your Honor.
Okay. I'm just making a note of that because I want to read it. I haven't read it in a while.
And, you know, unfortunately, our briefing in Ren on the constitutionality issue is not complete. It'll be filed later this, probably tomorrow, actually. Yeah, if we have any supplemental authority, we will cite it. But, you know, to give an example, that award was something like 32 times compensatory damages. It's just crazy. And
Well, it's my recollection in that case, it's been a long time. In fact, I'm probably going back to Dr. Desai's case. It's probably the last time I've read that. Yeah, because we had some issues regarding the application of State Farm, and I think it was based upon the motion for reduction, and I reduced it just a little bit over 10 times what the compensatory damages are. But I remember specifically when I read State Farm, I think constitutionality was addressed as one of the issues, and
it was, Your Honor. And I think so. I think the largest award, we did a survey of, you know, cases to see what the largest amount of, you know, times the compensatory damages were. And I think 13 might have been the top that we found.
Right.
And in Ren, it was 32. And to give you some examples, I don't know what the ask is going to be in this case, but I suspect it's not going to be an ask for compensatory damages of $1 billion or $3 billion, because maybe I'm wrong. Maybe I'm underestimating some people, and I never want to do that. But
they want to set records.
Yeah, you're the plaintiff attorney. You want to get what you can get,
right?
And I think they did a great job in Ren of underselling their case, and I trust that they may do that here. But the compensatory damages needs to be in some measure proportionate to the punitive damages need to be in some measure proportionate to compensatory damages, and to allow, and you know, obviously the court can also defer this and see what happens, because Mr. Rich presumably won't be testifying in the first phase anyways, but there needs to be some ballpark, some evidence for the jury to hang its hat on and say, this is the evidence we relied upon in deterring real water and in punishing real water. And that evidence shouldn't be, well, we relied upon the evidence from multinational mega corporation that owns, I don't know, one of them owns Pizza Hut. Pepsi? I don't know. Anyways, I watch too much YouTube. One of them or more owns food stores, they own restaurants. They're just not in the same industry. To say that they're in the bottled water industry is to really undersell it. And for those reasons, we think Mr. Rich's testimony invites error.
Oh, yeah.
Your Honor, I typically believe in, you know, motion, opposition, reply. But since Mr. Odou has jumped in the water for Mr. Kaufmann, I asked that I get to address some of the things that he raised that.
Oh, we can, because this is going to be an important issue. And I just kind of, I was making just notes on my tab here. I have down here to read Bon Jovi, read State Farm. And I thought about the nexus issue, and I just kind of summarized it. What evidence is permitted for the purposes of deterrence?
So that's where Mr. Kemp he and I were just discussing that.
Right? That's the bottom.
Exactly.
That's the issue.
That is it. So, Your Honor, this came up before. And one of the things, like I said, we discussed this with Judge Hardy, and I raised the issue that this came before you in a different way, because at that point we were concerned about the meter defendants and the punitive damages against them. Now, in that report, although Mr. Odou takes exception to this, bottled water and I believe real water was discussed in Mr. Rich's report. But an analysis of their financials were not done because they were bankrupt, so it did not matter. But Mr. Rich, going back to what you just said and what Mr. Kemp and I were just discussing, there has to be evidence, something for Mr. Rich to hang his hat on for his testimony. There has to be. So if you're going to deter others, which is what the statute says, if you're going to be able to deter, provide some deterrence, there has to be evidence to determine to use for purposes of coming up with that amount. So Mr. Odou has now conflated, I believe, or at least expanded what his motion is said to do. And part he's saying that Mr. Rich should not be able to testify at all. But then which I'm gathering. But part of it is because he's saying that Mr. Rich should not be able to use Nestle, Coca-Cola, or any other bottling company as an example. Mr. Rich did not use necessarily Nestle or Coca-Cola's complete financials. He used the bottle industry, water bottle industry as a whole. Because, Your Honor, he wanted to make sure he did not include anything extraneous to bottled water. So when Mr. Odou says, oh, this could have been something else involved, Nestle or Coca-Cola is a big company, they have other divisions. We made sure that Mr. Rich confined his numbers to bottled water exclusively. So that's not an issue. When Mr. Odou said this was an insurance issue, that we brought up something about punishing an insurance company, we didn't mention insurance. We didn't mention insurance companies. Mr. Rich didn't do an analysis of the insurance industry. Again, he confined himself to bottled water. And that's how the questions were.
I mean, I don't mind telling everyone this. It's a fascinating issue.
It is. And like I said, it played out a long time.
It really is, because I guess the real key or linchpin, what do you do when the defendant's in bankruptcy?
That was the other thing. So Judge Hardy, which is what you just knocked the door open on. Judge Hardy.
What do you do under those circumstances when the defendant's in
And
bankruptcy?
he said something, and Your Honor, I will tell you, and I thought this was I'm glad you're mentioning it. But Judge Hardy also
Corey,
said,
I listen.
he said, listen, so I guess what can happen is that a defendant can file bankruptcy when this lawsuit is going on, avoid the consequences of his misconduct for punitive damages purposes. The case gets, resolved, no punitive damages, and then tomorrow they reopen. They get out of bankruptcy and they start all over. They could use it to avoid the consequences of their misconduct through a bankruptcy proceeding. Now, I'm not saying that's what Real Water intends to do. We don't know if they're going to reopen, but certainly if that's the message we're going to send, then every company will do it. Because what they'll do is on punitive damages, sometimes that's not covered by insurance. They'll say, we'll let the insurance cover us for the compensatory, and then we'll use the bankruptcy to get out of the punitive damage phase. And when that's all played out, we'll start again. It cannot be used as a shield and a sword, Your Honor. And our expert should be allowed to testify because they've not given you any reason why he's not qualified to testify. They're now just concerned, it seems from what Mr. Odou said, to the amount. Well, whatever the jury decides, there's post-trial motions that this court can use to make sure it's within the constitutional constraints under State Farm. In the on the Delgado case, which I tried, Judge Gonzalez cut my number down. I asked for a certain amount of punitives. We got that amount of punitives, but she ended up cutting it down.
I cut the amount down in Mr. Kemp's case.
Yeah, Mr. Kemp said he lost like a $287 million day. I feel horrible for him. But the point is, you have a vehicle within which to make determinations after the fact. And I think Mr. Odou was somewhat alluding to that this won't come up for a while. But the point is, Your Honor, Mr. Rich should be allowed to testify because there are no hallmark reasons why he can't. There's no Williams decision holdings that prevent it. And in terms of how he ultimately provides his numbers, that's going to be done through a direct examination, subject to cross-examination. And then if the jury strikes the box, you'll have an opportunity to determine whether or not it's within the constitutional bounds. That's how it works, Sean. And so for that reason, I believe the motion should be denied in terms of precluding him. But in terms of these constitutional arguments, Your Honor, all of those can be handled post-trial or through the direct and cross-examination process of Mr. Rich while he's on the stand.
Okay, Mr. Odou, sir.
Thank you, Your Honor. Couple of things, because I know you'll find this surprising. I disagree with my colleague, Mr. Parker. We've argued this. I will agree with one thing. We've argued this a lot.
We have, certainly.
And
It's a fascinating
and I agree with
issue.
the court. It's an interesting issue.
It is.
So Mr. Parker's alluded to jury instruction. I found it. It's 12.1 from the 2018 version of the jury instructions. And in the jury instruction, we've talked a number of times about whether the financial condition of real water. What do we do with that? And the court in this case and the other cases has said, look, because they're bankrupt, you can't give that instruction. You can't give that little caveat in 12.1. And I'll address that in a second, but I want to address Mr. Rich in this motion because we're going to talk about punitive damages later. So Mr. Rich in his motion or in his report, in addition to the 16.1 violation, we have a violation of Philip Morris. And why I say that is because Mr. Rich gives an opinion as to the size of Coca-Cola, Pepsi, and Nestle on a nationwide basis and the bottled water industry on a nationwide basis. Not the bottled water industry in Nevada, the nation. And that's important because that distorts the number. If Mr. Rich was going to give an opinion that the bottled water industry in the state of Nevada in 2020 was X, I think plaintiffs would have a better argument. But that's not his opinion. His opinion is the bottled water industry in the United States of America is X billion dollars. And that's too much. And that's what gave the jury the wrong impression. The Philip Morris case requires that the punitive damages be for conduct conducted within the state. And clearly, real water was sold in other states. We don't have injuries in other states, except for one in California. But they're seeking to punish real water for conduct of the bottled water industry nationwide, not punish real water for the conduct committed in Nevada for the bottled water industry in the state of Nevada. And if we go there, well, then we come back to our old friend, Mr. Hallmark, that his opinion is not helpful for the jury. And we do have a Hallmark violation because his opinion is greater than the state of Nevada. It doesn't provide a helpful yardstick for the jury, and his opinion should be excluded. Going to the bankruptcy issue, I never raised the bankruptcy issue. I never argued in front of any jury that real water is bankrupt. And I don't.
Oh, no, I don't think anyone insinuated that.
It seemed like Mr. Parker did, and I was.
No.
Yeah, I didn't take it that way. I don't mind saying this for the record, because normally what happens when, and everyone knows this, but in the next phase, the punitive damage phase, you bring in the financials and those types of things at the company.
That's right.
And we don't have that.
We have it, we just don't have current. And what I mean by that is we do have a financial records of real water in 2019, 2020, those kind of things. Nobody has poured through those. No expert has done an analysis as to what real water's profit and loss was in 2020 when these plaintiffs were injured, or we have some 2017, 16, I don't know, maybe 2019, but anyways, we don't have an analysis from it. Could have been done as to what real water's profits and losses were in those years when the plaintiffs were injured. They could have done that. They chose not to. The fact that real water is bankrupt is a fact. We have to wrestle with that. We have to decide what.
And ultimately, that's kind of where I'm at now, because they're bankrupt.
Yeah, they are. And, we can look at the purposes and reasons behind bankruptcy. Again, I watch way too much YouTube. There's a lot of interesting videos about the founding fathers wanted no longer to have debtor's prison.
Well, I get that.
They wanted to have bankruptcy. People make a fresh start.
Yeah, Judge, I think we're getting a little ahead. We're on the motion for summary judgment now.
Mr. Kemp didn't like it when I made this argument before either.
No, you can make it, but I just think it really doesn't have anything to do with Mr. Rich, the motion eliminate. It's the next motion, it's the summary judgment.
Well, and I won't be arguing that one for everybody's relief. But the bankruptcy issue, it's embedded into the founding fathers. It was important to get a fresh start. So this argument that real water is going to commit heinous acts because they think they can get away with it because they can just declare bankruptcy and move on. First of all, that's not true. But second of all, we have to expect people are going to follow the law. That's a given. And to say, well, that now permits Mr. Rich to testify because we're worried that somebody is not going to follow the law because Mr. Rich didn't punish them to the tune of $3 billion. And that's really what their argument boils down to. And I warned the court I was going to take it to an extreme result. And unfortunately, the Wren jury took it to an extreme result. To allow Mr. Rich to testify invites that kind of error. And that's why we don't think he should testify. We don't think his testimony meets the Hallmark requirements. We don't think his testimony should be admissible for those reasons, and I think it's inviting trouble.
What do you do in a bankruptcy scenario where punitive damages are potentially a viable claim for relief? What type of evidence is permitted to be introduced in front of the jury?
And we talked about this in Gallagher, and we had offered it in Gallagher, and, you know, we offered to give plaintiffs the benefit of the doubt, let them introduce that evidence from the marketing plan that, you know, Real Water had revenues of $9 million a year. They don't hear that Real Water was out of business. They don't hear that Real Water is bankrupt. They hear that this is their revenues. It's just and it's evidence. It's not perfect evidence, but no evidence is perfect evidence. But it's something the jury hangs their hat on. And if the jury then still goes for, you know, their argument for whatever it is, $1.7 billion in punitive damages, at least, you know, they had a starting point. Otherwise, the jury awards the punitive damages in a vacuum, or worse, they award punitive damages based on a nationwide, which is also a problematic award.
How does it matter, if any, if ultimately, when it comes to the application of State Farm, the trial court's required to provide some sort of nexus from a constitutionality perspective? And I forgot, who authored State Farm? Was that Scalia?
Maybe
Maybe,
you have to look it up, Your Honor.
I bet it was.
Yeah, maybe.
Yeah, just the time, but it doesn't really matter. But what I'm trying to focus in on, is it that big of a deal in this regard? In that at the end of the day, say hypothetically, the compensatory damages in this case or X amount, let's say, I don't know what the claims are.
100 million, Your Honor, say 100 million.
100 million.
Yeah.
Okay. So no matter what happens from the punitive damage perspective, I have to follow the mandate of State Farm and limit that, right?
Right. We agree.
Yeah.
And so the question becomes, in limiting that in a post-trial motion, the law is fairly well settled. We agree. State
Yeah,
Farm provides
That's
support.
easy for me. That's what I did.
The question for this court is really, you know, it's a hallmark gatekeeping function. If you let Mr. Rich testify that the bottled water industry, you always said what the number is, I forgot, $3 billion or,
85 billion.
oh, geez, I was way off.
Yeah.
It's a pretty big industry. It's probably as big, if not bigger than carbonated soda, you know, it's huge.
Yeah, so that's the problem. He's providing testimony as the nationwide bottled water industry is, you know, whatever it is, $85 million. Billion, whatever it is, it just becomes a blur to the jury. It becomes confusing to the jury. That it's a number that is eye-popping, it's attention-getting, but it's not a number that is constitutional. And it suggests pointing the jury in an unconstitutional award. And that's really an interesting legal problem. Yes, it can be cured on the back end, but is it proper to admit unconstitutional testimony on the front end? We would submit it's not. And I think that's an interesting legal issue.
It is. No question.
And, you know, if the court needs to defer this because Mr. Rich will not be called until the punitive damage phase, then I don't know if that is agreeable to the plaintiffs, but that might be one option.
Well, I'll get it done before they get to that phase, because I do have to read. I'm looking here. I have to read Bon Jovi, I have to read State Farm, I have to read Philip Morris.
There's one other case, Your Honor, you should read.
I'll put it on my list, Mr. Parker.
And Your Honor, I want to make sure we stick to the Real Water's motion. Could you bring that up on his?
Because it's my understanding, there's real no.
No, you can have it. I just want to make sure you see what this reply says, because it's a little different than I think how you ended. I understood how you.
Well, I was responding to you, so we're going to go off script.
Your Honor, I think Joel decided to take the reins from Mr. Kaufmann. But Your Honor, this is.
Patty? Can you move back by a microphone, please? I'm sorry, I can't hear you when you go over there.
All right, that's the, can you hear me now?
Yeah.
All right, good enough. So, Your Honor, this is the reply brief from Real Water. So you
And what page?
This is the last, page 5, I think?
Yes.
Yes, page 5, Your Honor.
Do the punitive summary judgment one next.
Go page.
Yeah, might as well.
So it says in reply brief, the main thrust of plaintiff's opposition is that their expert Mark Rich is qualified as an expert under Nevada law. This is not being challenged.
No, I get that. His
this-
credentials,
It
qualification.
says, and the methodologies. The methodology goes to how he came up with his numbers, Your Honor. So my point is, what Mr. Odou just said conflicts with what their reply brief is saying. They're not only saying his qualifications, but his methodology, which means they're not contesting him under Hallmark. So in terms of this motion by itself, on its face, the four corners of this motion, the motion should be denied, Your Honor. What they're talking about in terms of what he may say relative to the numbers, I will tell you, in our opposition, we point out what Mr. Rich said in his report and during trial. And the numbers for Pepsi, Coca-Cola, Nestle are hundreds of billions of dollars. We didn't ask for that. We confined it again to this space. The other thing I wanted to point out, which I'm going to be brief, Real Water is now raising issues that should be dealt with post-trial in terms of not only constitutionality, but the breadth of Mr. Rich's testimony under State Farm. Well, I want the court to really understand that Real Water was being sold in Florida, California, Nevada, Arizona. They were in several markets.
Please argue.
Oh, I'm sorry, we couldn't understand what you were saying while I was interrupting you, Mr. Kaufmann.
Go ahead, sorry, I was yelling at my dog.
I didn't want to keep interrupting you. You
No,
jump
it's-
right in. Tell me when you
The
want to.
dog is interrupting. It wasn't Mr. Kaufman.
Oh,
I
okay.
apologize.
No, that's all right. I didn't hear dog. All right, so, Your Honor, that's where we are. This motion should be denied as to Mr. Rich. In terms of the numbers, that's something that the court can handle afterwards. Because their reply says they're not questioning that. His methodology or his qualifications. In terms of the numbers, understood. I think that's a justifiable argument.
What page is that again?
This is the last page, page 5 of their reply brief, Your Honor. And he also says, go up a little bit more for me, Shane. He also admits and concedes that Nevada Supreme Court has said, and he says it's in line 10, while Nevada may allow the consideration of deterrence in a punitive damages context, that does not mean that plaintiffs can prejudice the jury by implying national harm has been done. Well, some of the complaints that the court has already allowed him to be pre-admitted are from people outside of Nevada. Mr. I think Fisher is in Tampa, Florida. Ms. Kessler, I believe, was in California. Real Water is being sold in Sprouts, Whole Foods, Costco, Albertsons, Terribles. All over these are very large companies. They're being distributed by KeHE, Nevada Beverage, UNFW, very large distributors. So to simply suggest that this is just a local Las Vegas issue, it's not. So I would ask that the court deny the motion, and then in determining whether or not the number ultimately is constitutional, the court has many ways of dealing with that post-trial. If we get there, it depends on what the jury does in terms of striking the box, John. If I raise anything new, Joel, go right ahead, I'm sorry.
And it's an important issue. I don't mind.
Oh, the case I wanted you to look at is Ace Trucking, Your Honor. That's the other
Yes,
case.
that's the right.
That's it. I just want to make sure. I'm glad we're on the same page.
Wait,
That's
wait.
it.
Ace Trucking, Your Honor.
The Ace
You
Trucking.
have the site you need, because I can pull it if we need it.
I don't know. I don't know if I
Give me a
have the
minute to
site.
get it.
So we have Bon Jovi, State Farm, Philip Morris. Now we have Ace Trucking.
Yes, sir. And that's a Nevada case. And the Ace Trucking case, you probably remember that, Your Honor, but I just don't have the site, but it's a Nevada case. We can
We can find.
I think so.
You have the site, ma'am, 103?
We're finding it, Chairman. I want to make sure we get to the right one.
It's 103 Nevada, 503, Your Honor.
And then the Pacific is 746 P.2D 132.
Yeah, it's actually cited in the next motion, in the summary judgment motion on page 15 of our opposition.
Okay.
In fact, a lot of these cases are cited because they're pretty much the same issue.
Thank you, Your Honor.
I just want to make sure I'm not missing anything. We have Bon-Jovi, we have State Farm.
That's right, Your Honor. We should have BMW, the US Supreme Court case, 517 US 559.
What's the next?
I suggested, Joe, we do the summary judgment because it's the same.
Yeah, we-
issue we're talking about.
Oh, okay.
There's the court has a Philip Morris site, because I have that if you need it.
Let me see here. Yeah, give me that site.
It's 127 Supreme Court 1057 to 2007 case.
127 Supreme Court 57.
Yes, 1057, 1057.
Okay. I will read them. And we need a break, don't we?
Yes.
Let's go ahead and take a break. Okay, we're back on the record and we're gonna go to the punitive damage, right?
Who's got that?
Yes, Your Honor.
Which one is that? That's, yes. Yeah.
Which one are we doing? Punitive damages. I'm just looking at the docket number.
It's 547.
Afternoon, Erich Storm for real water on this particular motion.
All right.
This one dovetails with the last motion argued in this motion number 15. I think a lot of the briefing we did for the summary judgment motion has been addressed already, so I'm going to have kind of an abbreviated quick statement. This case is proceeding by virtue of lifting of the stay order from the bankruptcy court. That in turn is based upon the stipulation of the parties. We had inadvertently attached as Exhibit A to the summary judgment motion the wrong stipulated order. So this morning, sometime around 11 o'clock, I think, I filed with the court and served a substitute stipulation and order for lifting the stay. I'll say that in its operative language for our purposes today, the erroneously filed document and the correct one are the same. So it doesn't really materially affect anything that we have argued. So I want to point out to the court that a stipulation of the parties, the stay was lifted for this action to proceed in its entirety to the extent that there is insurance coverage for the claims, if any. And that is contained in the order, which is now the second to the last page of the document I filed this morning. In paragraph 2. That reads in part under subsection A that to the extent necessary, the debtor shall only be a nominal party to the litigation. The intent of the parties to the stipulation being obvious to me anyway, that being a nominal party, it is not to incur liability, given the fact that it is in this chapter 7 liquidation proceeding. Subsection B goes on to say, in the event that an adverse judgment or other adjudication or determination of any liability of the debtor is made arising out of the litigation, our case today, the claimants will look solely to the debtor's insurance coverage, if any, for the recovery of for their alleged claims and damages asserted in the litigation, and shall not seek to enforce any such matter against the debtor directly. But what I like to say here is that under Nevada law, as we see it, public policy precludes liability carriers and the ones that involved in this particular case from insuring an insured against exemplary or punitive damages. As a matter of public policy, they are not covered. That being the case, this stay order is going to preclude any further litigation of the punitive damages claims. If there is no insurance coverage to satisfy the punitive damages award, it shall not be pursued quite clearly by the agreement of the parties as adopted by the court. The opposition is taking the position that, well, the carriers in this case had the opportunity to accept offers of judgment. Therefore, because they were rejected, the insurers are potentially liable for basically extra contractual claims. However, these carriers are not part of the litigation. Extra contractual claims are not part of the agreement. And an extra contractual claim would necessarily be a claim belonging to the debtor, not to the plaintiffs. It seems to me, and I'm no expert by any means at bankruptcy proceedings, but if the theory of the plaintiffs is we can get a judgment for punitive damages and proceed against the insurance company, not as proceeds of the policy covering the defendant debtor, but as separate extra contractual damages potentially available to the debtor, we'll just take an assignment of that debtor's rights against his carriers. But that's precluded by the subsection C of this agreement. The parties agreed that the claimants waive any claim they may have or could assert against the debtor, which in effect would be, we want an assignment of the debtor's claim. That provision goes on to say that the plaintiffs or claimants waive any right to distribution of the bankruptcy case in exchange for their ability to go forward with this action. So I'm not sure where we're going with the punitive damages claim to begin with. The claims are not covered by law in Nevada in this action, and they're not recoverable against the debtor as a nominal defendant. And we have an irrelevant argument being made in opposition about extra contractual damages potentially accruing on behalf of the debtor against his carrier due to offer of judgment rejections, which simply are beside the point. They don't get around the ultimate problem that the plaintiffs face. The stipulated order says they are limited to recovering damages that are covered by insurance, and nothing in the opposition, in my estimation, really successfully addresses that handicap. Again, the remainder of the defense motion is kind of subsumed in what we're talking about in the context of motion eliminate number 15 before we did break. So I'm not going to make any comment about that. But it seems to me that it's pretty straightforward under our stipulation of the parties and the court order, and the bankruptcy proceeding simply precludes the punitive damages claim from going forward. Thank you.
Your Honor, this is the fourth time I've heard the argument that we stipulated to dismiss the punitive damages claim in the bankruptcy stipulation. Clearly, we didn't do that. That's not what it says. And it's been rejected 3 times, once by Your Honor. But the exact language of the stipulation is this, quote,
And what page are you at, Mr.?
I'm on page 2 of the supplemental thing that they filed this morning.
Yeah, I have the stipulation right in front of me.
Okay.
And I'm on page 2 of the stipulation.
Right, and I would point out, we drafted this. You see, it's on our letterhead. We drafted this stipulation. And we know how to say that we're going to drop our punitive damages claim if we wanted to. But it says, quote, in the event that an adverse judgment or other adjudication or determination of any liability of the debtor, any liability, which would include compensatory damages, which would include punitive damages, is made arising out of the litigation, the claimants will look solely to the debtor's insurance coverage for recovery. It doesn't even say that it's only if the insurance policy covers punitive damages. It says that our payment will come from the insurance company, not from the debtor. And we continue to say that we will not seek enforcement. So it's pretty clear, I think, what the language says, and it doesn't say that we're stipulating to drop our punitive damages claim into litigation. Backing up, the original thrust of the motion is that we should drop the punitive damages claims because they're insolvent, they're dead. And, you know, in other litigation, we've called that the hobo theory. You can't get punitive damages against a hobo because he can't afford to pay anything, so you should just drop the claim. You can only get punitive damages against Steve Wynn or just Jeff Bezos because they can respond to it. And again, we've argued this is the fourth time we've argued this point. And that's why it's so important what Mr. Parker was saying. The statute says punishment or deterrence. We don't have punishment in this case because we've agreed that we're not going to seek to collect against the debtor. That's the first reason we don't have punishment. The second reason we don't have punishment is they're insolvent. They filed bankruptcy. They're a dead corporation. So we're not dealing with punishment in this case. We're dealing solely with deterrence. And deterrence, you know, we had a long discussion about this before, Your Honor. I think the real issue boils down to if the objective of the punitive damages is deterrence, what evidence do you offer to the jury to provide them some sort of guideline? You know, and I think Mr. Odou said this today, and he also said in front of Judge Hardy, you've got to give him some evidence. All right. So the evidence we used in Judge Hardy's case was what was the bottled market, the bottled water market industry, 85 billion. And we actually had one of the expert, someone from the board of directors testified for the defense from the International Bottled Water Association. But in any event, you have to give them some guidelines. And, you know, otherwise, we're just saying we want to deter others and we're just giving no guidelines. The jury could say, okay, let's do $1 trillion. You know, that would not be appropriate. So you've got to give them something. I think Mr. Rich, giving them the examples of other big people in the bottled water industry is the appropriate way to go. But getting back to the main point, their summary judgment wants the punitive damage claim to be thrown out because they say they're a dead corporation. Yes, that eliminates the punishment aspect of it, but it doesn't eliminate the deterrence aspect of it. Directly addressing counsel's point, he says that you can't give punitive damages because they're extra contractual. Well, it's not extra contractual. It's the consequential damage that results from the insurer's refusal to pay the offer of judgment. It's a consequential damage. We have 2 cases right on point that we cite in the reply. Number 9 is on page 9 is the Carpenter case. And same fact pattern in both cases that we have here. The insurer refused an offer within policy limits, and then there was a compensatory award and a punitive award. And the insurer said, we don't cover punitive damages, so we're not going to pay. So the 8th Circuit in the Carpenter case, and let me just read the quote that we have in the brief. They acknowledged that the subject insurance policy excluded coverage for punitive damages, but they held that the insured was entitled to be made whole, which necessarily requires her to recover the amount of the punitive damages awarded in the underlying state court action. So in that case,
And you know, what's really important to point out though, and this is overlooked, but the insurance company has a special relationship with
exactly,
this
Your Honor.
is insured, right? It's akin to a fiduciary. That's what Nevada law says.
Yeah.
Consequently, you just can't leave your insured out there.
So you say, we're gonna roll the dice, you know, and the consequences, those aren't our consequences, they're your problem, you know? That's really what the argument being made here. And that's been rejected by most of the cases. We cite another one on page 10, Williamson versus Green. Quote, if an insurance policy excludes coverage for punitive damages, that does not absolve an insurer from liability for all losses flowing from the breach of its duty to settle claim, including for a foreseeable award of punitive damages against the insured. I mean, that's just black letter law. If they reject an offer of judgment, it's determined later to be a reasonable offer of judgment. And these offers of judgment are so paltry, it's surprising. You know, you look at the offer of judgment against the ultimate verdict, say in the Wren case. I mean, I don't want to give the numbers out, Your Honor, but it's like, what insurance company in their right mind could have rejected this? But that's an issue for another day. But the point is that they're liable for consequential damages, i.e. the punitive damages, if they made an unreasonable rejection of the offer of judgment, whether or not the policy covers punitive damages. Now they say, oh, Judge, it's public policy here in Nevada that insurance companies never have to pay punitive damages. That's what they said. Well, that's not what this exact same insurance company said in the debt relief action. In the debt relief action that they filed in federal court, they said that under Nevada law, you can insure for punitive damages. That's what they told the federal court in their debt relief action. And that is the law, because sophisticated companies like MGM, they go to Lloyd's, they get insurance for punitive damages. In this very case, Terrible Herbst has insurance for punitive damages. That is what the law allows, and that's what these big sophisticated companies are doing. So not only is that what's going on, but they told that to the federal judge. They said, Judge, under Nevada law, you can insure for punitive damages. Now, the debt relief action has not been determined because when the bankruptcy court said she's going to send everything back, which is what she's doing now, she filed a written remand order. Within 2 hours after her giving us that oral decision, they dismissed the debt relief action. So they dismissed the action that they filed, saying they don't have that. This is from the debt relief action. This is their allegation. Quote, this is exactly the opposite of what he just said. Nevada law allows an insurer to insure against legal liability for exemplary or punitive damages. And that is true, Your Honor. So in this particular case, we have the punitive damages claim. We're not asking the court to determine that the insurance company is liable for the punitive damages at this
That's
point.
another day, another court.
That's another day. I mean, I think the case law is pretty clear on this, but we're not asking for that determination to be made. But the fact that we need to get the punitive damages before we go to that next step. So this motion should be denied because, you know, for all the reasons I've said, and like I've already said before, we've argued it 3 different times. And just because you're dead insolvent doesn't mean you get to deduct the punitive damages claim. Thank you, Eric.
Your Honor, my office is not retained by the carrier that filed the debt relief action. Number 2, as I can gather, that was dismissed anyway, and there was no determination of any of the issues on the merits. So I'm not too sure what that has to do with anything. Why we're here today for. Now, counsel argued that consequential damages can be punitive damages, therefore somehow the defendant, the punitive damages claim against the defendant in this case should proceed. Well, the case law that counsel's referring to is calling consequential damages those damages sustained not by a claimant, but by the defendant due to the conduct of the defendant's own insurer. This has absolutely nothing to do with the present case or the motion that the defense filed and that we're arguing today. It's very simple. The stipulated order says that if a claim is not covered by insurance, you can't proceed with it. It's that simple. We'd ask.
I mean, ultimately, somebody's going to make a determination as far as that issue is concerned. Whether there's insurance coverage in this case, and that's not me. Right? I don't have a debt relief claim or a cause of action pending in front of me where I have to dig deep in insurance policies and make determinations as to whether or not there's coverage. I mean, I have some cases, in fact, regarding COVID, where I have to make that type of decision. But, and I don't mind telling you this, I didn't venture into bankruptcy court very often, but I bet I've ventured there at least 100 times seeking relief from the automatic stay to proceed against insurance policies only.
Sure.
And my point is this, that's another day. Right now, I have to deal specifically with the claims for relief in this specific case. There's claims for compensatory damages, general damages, special damages, and also punitive damages. And I don't think that this order is a bar to any claim as it relates to punitive damages. And that's kind of my point. Because if it was, I would expect it to be explicit as far as the stipulation is concerned. And I don't see that, right? And I mean, I understand what's going on here. I mean, ultimately, at some level, someone from the insurance carrier is going to have to make tough decisions as to what coverage is available and how much they want to pay to resolve this case. And I understand potentially too that the bankrupted party or the debtor or whatever you want to call it, whatever they see in bankruptcy, they have certain, even though they're bankrupt, they still have certain rights as a company, and they have indemnification rights pursuant to the insurance policies at issue, right? And insurance policies are assets. We can all agree. So I'm going to deny the motion. I really do. I mean, I think I need explicit language in that regard, because I'm looking at it this way. We're going to go to trial and there'll be claims made, and we'll have jury instructions, and the jury is going to deal with both general, special, and punitive damages. That's what they're going to deal with. And whether there's coverage or not, that will be another day. That'll be decided by someone else. And the level of coverage, that'll be decided by someone else, not me. That's kind of how I see it. So I'm going to deny the motion.
I need to step out.
Oh, sir, you
don't want to be rude.
No, not at all.
Thank you.
More than welcome. Have a safe drive. What's next? Or should we step down?
No,
We got more.
We're getting close to the end.
Are we?
Yeah.
Do you believe that?
You can call us liars.
What's next?
We have 7 motions left.
We have 7 motions left.
Yes, that's the good news.
All right.
So next on my list is docket 545, which is Real Water's motion eliminating number 16.
Your Honor, Joel Odou on behalf of Real Water. This court's rulings has made that chart prepared by Dr. Robin inadmissible on other grounds. And so we'd like to withdraw this motion. And if we're going to seek to admit a chart, we will make sure that chart complies with the court's rulings and motions eliminating. And seek permission, because right now that chart is not in compliance with some of this court's prior rulings.
I'm fine with that, Your Honor.
Okay, I won't get in the way. Got what you need?
Next up, I have docket number 546, which is Real Water's motion for partial summary judgment to prohibit damages under NRS 41.085.
And there was no opposition to this one. I believe they're working on a stipulation. There's a stipulation that will be coming on this one, so
Okay,
we could put it over and just.
No, this was the one that was
How was it
the
doing?
wrong. Oh, yeah, okay. Yes, that's correct.
All right, I asked the boss.
She's keeping track. All right, so moved by stipulation, is that?
Yes, Your Honor, that's correct.
Okay,
okay. Next, I have docket 548, which is plaintiff's motion limiting number 6.
Withdrawn.
What's what?
Withdrawn.
Okay. There we go. Okay, next is docket 552, which is Real Water's motion limiting number 14.
And this one will be real quick. I won't even go to the podium. It's a short motion that's very specific. It's to preclude arguments regarding the duration of discovery and all the depositions. We're not requesting the preclusion of the proper use of discovery disclosures, the proper use of deposition transcripts, expert reports, and discovery responses. What we are looking to preclude is statements and slides that show a timeline of the duration of the discovery phase, the number of pretrial filings there were, how many depositions there were, because that all, it's improper and prejudicial in that it gives, it confuses the jury. It gives them the impression that Real Water did something improper, that they forced the plaintiffs into something that was unfair. It's irrelevant and it doesn't have any context. At this time, Real Water is the last defendant, and the jury is not going to be told of the other defendants involved, the discovery that the other defendants did, discovery on the other claims, their settlements, others' participation in the case. All they're going to hear about is, here are these plaintiffs, here's when they filed their complaint, took all this time and all this effort to get to trial here years later, and it's all because Real Water is forcing plaintiffs to do this. They're they're unfairly making plaintiffs do all this work, and it just really is very prejudicial to Real Water. So that's what we're asking for, that specific slide and argument to be precluded. Thank you.
Your Honor, this has also been argued before in front of you, in front of Judge Kishner, and in front of Judge Hardy. All three of you have denied this request. The slide that we're using, I used during my opening in all three cases, Your Honor. It's simply the truth of what these plaintiffs have gone through. What we have done, we have sanitized it a little bit. I've worked with defense counsel in the past, so we remove depositions that don't relate to these plaintiffs. We talk about the depositions that relate to this case, this claim, or these claims. And it does have an accurate timeline. And when there's been some concern about the dates, I've gone over them before my opening to make sure the dates are right. I've shown these slides to Real Water's counsel before we did the openings. And again, every trial that we've been in, all three leading up to this one, Your Honor included, have denied this request on behalf of Real Water. Your Honor, their request, in my opinion, is simply trying to prevent the jury from knowing how much effort it took to figure out what they were going through, why they why we needed experts to determine what their conditions are and what caused their conditions, their illnesses. All of the claims that came before Real Water that were ignored, that all goes to, again, in part to the punitive damage claim. And it puts into context the efforts of these plaintiffs just to get some form of justice. And so, Your Honor, I ask that you do what you did the last time, allow this information to be put before the jury. And I think it's consistent with what has happened in this case leading up to the time of trial. The only other thing I would point out, Your Honor, and under our rules, pleadings can be read to the jury if we chose to. A lot of this information could be is contained.
For example, you could read the complaint.
To read the complaint, so they would know the date of the complaint.
I don't even think we do that much anymore. Here's my point, and I think this is really important, and this is, I mean, I don't mind telling everyone, I actually address this issue tangentially when I talk to the jury and my jury selection process. And what I mean by that is this, because I think juries think that, when a case goes to trial, it's akin to Law and Order.
Right.
And what I mean by, and I always make that reference, and the reason why it's important is they think, maybe this case happened last month or last week, or not last week, but, within the last year. And they don't really understand and appreciate the efforts it takes to marshal a case to finality before a jury.
That's right.
And that's one of the things I tell them. And I think it's really actually kind of fair to both sides because they understand and respect the efforts. I've even lately been telling them that probably for every hour you see them in court, lawyers spend 50 to 100 hours outside of court.
That's right, John.
I mean, and that's true because it takes a lot to marshal these cases, and I'll say this, that's what I sometimes, when I look at some of the more complex cases, I remember when I was presiding over Enrique Kitech, what I found fascinating, nobody picked up on this. I remember they were showing pictures of the fitting depository. And I sit back in amazement, and I think they had like 20,000 fittings or whatever. And just from a administrative perspective, what did it take to do that?
Right.
And I get it. And I think the reason why my first job was with the firm that did that type of work. And I know it takes a lot. It's not just walking into court that day for that motion or, sitting in front of the jury, introducing yourself and starting opening statements. These cases are very complex. And I'm trying to figure out what would be the prejudicial harm in telling the jury. Because I think I try to do that because I want them engaged. I want them to understand that this is not Law and Order. It's not a scenario where the first 5 minutes the crime occurs. Then they call it
30 minutes later, you're in the trial.
Yeah, exactly.
That's right.
And I will say this, I don't mind telling everyone this. I think juries at that point become more engaged and realize that this is not Law and Order. This is real life. It takes a long time for these cases to get here, sometimes 3, 4, and 5 years. A lot of work goes on behind the scenes. And I just kind of let them know that. And I think another reason why it's important, I think they treat the case differently.
Right.
And it's something I do in every case.
That's right.
I do when I do my little intro because as you know, I prep them for you. I get them ready for you.
You do.
And that's,
yeah. Unless the court has any questions, I think I just asked the court to do exactly what he did the last time and what every other judge has done in this one. And it's allowed the factual procedural items that have come before, like depositions, the complaint, all of those dates are important. And in fact, we ultimately put those depositions in front of the court and in front of this jury, either by way of video depositions. Sometimes we'll have to publish the depositions so that we can remind some of the witnesses of what they spoke about. But it gives a timeline, and that's what that slide is designed to do. And it is fair to both sides because it indicates depositions taken by both sides of the fence, both sides of the beat.
I excuse me, I understand your ruling, Your Honor. I just wanted to bring up, what you said about how you like to tell the jury how much work the parties put in and the attorneys, the court put in. Where the prejudice.
I don't even say the court, actually. I focus on for example, when the lawsuit was filed and because juries come in, they're under the impression, they really are. They think that whatever happened was within a reasonable period of time. They don't understand the efforts it takes to marshal a case like this to a jury. They don't get that. And that's what I'm trying to say, because there's a lot of work that goes on to get these cases there. And at the end of the day, I'm trying to figure out what will be the harm or prejudice to anybody. Because I think what happens when I key them like that, or, I get them there, they really start focusing in and say, yeah, this is an important case. Took them a long time to get here. I'm going to pay serious attention to this case. And that's another reason why I spend a lot of time on what are jury instructions. I do, because they have no clue what they are, what the law is. They don't have in a general sense, they don't understand what their role is. I don't mind telling you this every time I've gone in and swore in 4 panels in this case, right? For the jury selection process. And I swear them in. And just as important, I read jury instruction, Nevada pattern jury instruction number 1 out of the 1986 Nevada pattern jury instructions. And the reason why I do that, I want to make sure that when they fill out or answer those questions, they're being truthful and forthright. I want to make sure they give complete responses. I want to make sure they understand that once they answer that first question, they're under my jurisdiction. Right? I make sure they understand that. And just as important too, and I think they really like this, I don't mind telling you this, the fact that I tell them, look, we're doing this for your convenience. So you don't have to sit down there for 4 or 5 days like we used to do in the old days, waiting for your panel to be called. And they appreciate that too. And so I'm just trying, so what I think my role as a trial judge, I don't mind saying this, part of it is education. Educating the jury as to why they were selected and why they were here to serve, right? And I think that really helps the engagement of the jury, and they take it seriously, and I think it's worked out fairly well. We've had panels that want to become permanent jurors.
Well, and I think it's very important, and that's what goes to my point, is that you presented to them how important this is, how much work has been put into this by everyone. And what is different, and I find prejudicial, is that plaintiffs frame it in a way that is like, look what, they said, look what it took for these plaintiffs to get some form of justice. And that implies that they were forced to do this by Real Water, or that Real Water did something nefarious to make them go through all of this to get some form of justice. And that's where I think the prejudice comes in. If it's presented as, hey, everyone really worked hard on this and it took a long time and you need to really be serious about your job here as jurors, that's one thing. But to indicate that,
Here's my question
there's
for
a bad
you.
guy.
That's not really evidence subject to emotional illness. That would be more argument. And how is that an impermissible argument? That's really and truly what it is. And just as important, I mean, isn't that the issue?
Thank you.
Thank you, Your Honor.
I mean, really it is though.
That's right.
I mean, it's not a motion to limit. It's not to seek to pre-admit and or exclude evidence.
Right.
That's argument. And it's not Leoshi. It's not, what's the other one? Leoshi and, Flick versus the Jesus. I'm pretty good. But that's not what we're dealing with here. And so the only reason I wanted to dig a little bit deeper into that issue is I just want to make sure we have the right record. I'm going to deny the motion for that reason, because we're talking about argument. And I don't even think it's inflammatory or anything. It's just, and it'll be, because I can tell you this, I'm going to, like I do in all cases, and I think it's important for the jury to understand the efforts it took to get here. And I have never had an objection to that. Right? Let's go to the next.
Next, I have docket 558, that's plaintiff's motion of limine number 15.
Eric, this is the one that you and I spoke about, and we have an agreement on that.
Yes, Your Honor, I don't think there's really much of a dispute with this. I don't think Real Water intends to make the argument that the permitting or inspections, warranted the safety of their product. So I think, it was granted in the last one, just for record purposes, it's granted in this case as well, but I don't think there's really anything left at issue in that one.
Mr. Odou, sir.
Your Honor, we agree. Mr. Pepperman and I had a very distinct argument, or not argument, agreement and discussion, and we talked about the issue is really where the line gets drawn. We have an understanding as to the argument that we made in past cases are going to be fine in this case. And we didn't argue that any compliance with any law excuses the fact that there was hydrazine in the water. There shouldn't have been hydrazine in the water.
Right.
And so there is going to be testimony and argument that real water are not evil people. They didn't intentionally do this. They complied with drinking water standards, but drinking water standards were inadequate to protect these plaintiffs from hydrazine. That's conceded.
Well, we need to send a message to the industry.
That's right.
Yes, Your Honor, subject to the motion in limine 16, which has been taken under advisement by the court. This motion 15 doesn't touch on any of those issues, so it relates only to the delegation of obligations. We passed a permit inspection, we were permitted, that means the product is safe. That's what this issue pertains to, and there's no dispute as to that.
Just making sure.
Yeah, and that's fine. I mean, for example, just because you have an inspector come out and inspect the framing doesn't mean that the framing is correct. Is that correct, Mr. Parker?
Absolutely.
And or the trusses.
Exactly right.
Long time ago. I remember them all though, Mr. Parker.
Oh, golly, that was a long, that was 2011, 9?
Something right in there,
Yeah.
but I remember that case. I enjoyed that case.
That had a lot of issues.
A lot of issues.
Was there an agreement that it's granted?
Yeah, that's fine.
Okay.
Okay, next up, I have docket number 560, that's plaintiff's motion in limine number 33.
And I think this should be fairly quick, Your Honor.
We agreed on this one too.
Yeah,
The Zero matter of death.
Yeah.
Yeah, so basically we agreed if the door is not opened, we don't intend to offer the manner of death. In particular, the issue is, if they say that he committed suicide because of real water, then we have to argue the issue in front of the court.
Your Honor, I think it should be precluded even subject to.
Well, we're not saying
Open
he
that
committed
door.
suicide because of real water. The fact of the suicide will be referenced.
Yes.
That doesn't open the door to the manner of suicide. Subject to that, I think, sounds like we have.
Yeah, as long as there's not an argument he committed suicide because of real water, we're not gonna argue with you. If there's an issue, we just want to be able to argue to the court that the door is open, but it doesn't sound like you're gonna open the door.
Yeah, I think you can raise it. I don't know that would really open the door to this, but I don't think that's gonna be an issue because we're not claiming he committed suicide for real water.
It's a rather gruesome fact. I don't think either side wants to raise it.
Yeah, I don't think it has.
So, ma'am,
any.
So what do I do? Granted pursuant to the stipulation the parties placed on the record?
That would be acceptable to us, Your Honor.
Yeah, that works.
Okay.
Anything like-
You got my get.
We thought that was it. There's
You aren't official.
So-
If you think it's it, I'm out of here.
a motion number docket 565. That they're gonna oppose and then we're going to hear at some point before trial.
That's the
Yeah.
Herbst redid.
That's
Yes,
the one that we set as a tickler, so it didn't get lost.
Okay.
So only one left is the adulterated.
no, and adulterated if we don't come to a stipulation, but I'm pretty confident we will.
With the tickler motion, maybe if we could bump that to someday next week as if we're before the court again. Not sure.
Oh, we're before the court again. But whenever we want to do it, whenever you want to do it, it's
For
fine.
a second, there's a motion to seal.
That'd be fine. If it's okay with the court, we'd be fine with that.
I'm fine with whatever you agree to, if you agree.
October 2nd.
I think we need to get that adulterated issue in the morning.
Yeah, you already said they're gonna stipulate.
Okay. All right. Whatever it is, just have it done over there.
Yeah, I think October 2nd should work.
Okay, so just continue it to that same.
That would be wonderful. We appreciate that.
And then put in there the parties are gonna try to work out a stipulation.
Okay.
So we're done? We're done, Your Honor. Thank you so much for
Thank you,
your
Your
time.